The 50th day of the trial for breach of trust against Dr. Reiner Fuellmich. The main defense attorney, Claudia Jaworski, delivered her closing argument. She had speaking time until 12 o'clock. In response to the last accusation of verbosity, she said, "You, Mr. Chairman, might have liked to witness a proper plea. I, on the other hand, would have liked a proper criminal trial." In her plea, she outlined the historical course of the proceedings, pointing out various procedural errors and other strange flows of information. In regard to the accusation of infidelity, she surprisingly presented a chat history, which shows that the complainant, Dr. Justus Hoffmann, knew that the GOG did not own the donations, even though the criminal complaint suggests that the alleged embezzlement was supposed to have been committed to the detriment of the preliminary GOG. After the principle of in dubio pro reo, the client should be released immediately. Attorney Siemond picked up on this circumstance and demonstrated in his supplementary plea that the adhesion claim thus appears to be an abuse of rights. Furthermore, Dr. Fuellmich begins his final statement today. He started with the words, "I will present evidence at the end of my speech that will show this is a rigged game to sideline me because of my investigative work. And of course, I can use a private loan for private purposes. If the loan was given with the condition that I return it, then that's the end of it." He meticulously demonstrated the development that led to his alleged expulsion from Mexico. During his presentation, he was reprimanded 5 times by the chairman for various reasons, which led to just as many motions for bias against the court. We will see if this number will increase. Yes, what are your expectations for your court day today?
I no longer expect anything from the rule of law.
Okay.
It is being made absurd. It's just embarrassing. For 1.5 years, they detain a man in shackles, like a serious criminal. It's unbelievable. But the rule of law is dismantling itself right now. I hope that this will come to light at some point, at the latest in the history books. People will be put on the same level as the Jacobins and others here.
Do you see a case of infidelity?
No, not at all.
What convinces you?
What convinces me? Well, I don't know Reiner Fuellmich personally, but he once got me out of a tight spot with the meat high brise. And he came across to me as a fundamentally honest person who truly seeks justice. And it is absolutely unimaginable that he would let himself be drawn into such a criminal act for such a trivial amount to him. Absolutely incomprehensible. But that's the envy of others, because he is so talented, in my opinion. I can't say more about it.
Yes, thank you very much. Mr. Schmidt, good morning. The verdict is coming within reach. What is your realistic assessment? What will it be?
Whether it is already within reach, I still see everything as open. So, I see everything as open. Let's see what comes in terms of pleas. Which lawyer or lawyers will come today? So, whether the defense is present, it will be very exciting.
What brought me here? Yes, I'm curious if something will happen today. And I'm looking forward to seeing my friend.
Yes, my friend.
Friend? He doesn't like me that much. I spoke to him yesterday.
Who is the gentleman again?
He's one from the hater chat.
Okay. That was the gentleman. I pixelated.
That could be. It's quite possible that he ran down to the map. Yesterday he insulted me again, and with witnesses. That might not have been very clever.
Okay. Okay, what else do you expect from today's trial day?
Ideally a direct acquittal. I watched the video yesterday from this lawyer and the attorney. Explained it really well. If there's damage and the money to cover the damage is actually there, such a trial has never happened in German stories. Thank you.
Good morning, the defense team. Will the closing arguments be made today?
We'll see how far we get. Can I say something beforehand?
Simon?
Yes, we'll just see what the court has prepared for us today. We also have a few things up our sleeve. We'll definitely play those out.
Why was the adjournment not present yesterday?
Well, I wasn't present yesterday because I'm only here for a specific aspect that I might bring up again today. Thank you.
Mr. Whittle, perhaps a brief feedback?
Yes, that was quite intense, Katja's plea. We think she did a great job, and I still need to process it a bit. And there was a lot of information. And when you hear it, it's just pure, clear innocence, must be acquitted.
Yes, I'll say it as I said before. Quite clearly, my feeling is that the stamp has been set. No matter what is presented, no matter what truth is brought out. Again, even the refusal of evidence clearly says the stamp is set, the verdict is already made somewhere. And it's unbelievable that everything that is now so wonderfully presented by the lawyers and what is reiterated and clarified again, that it doesn't matter at all. I just find it simply shocking.
Katja Wörmer delivered a really strong closing argument here. So, also I felt it very emotional, especially at the end. She laid it out so strongly that they should simply be acquitted here. There is no intent in dubio pro reo, or whatever it's called. And yes, now he has to let it all sink in.
Ms. Henning, a quick feedback. I see you were stung by a bee. I'm sorry.
It was a wasp, and I think it shouldn't have stung. I might still have to file a complaint about that because I was told they simply don't sting at this time. Well, we'll discuss that. Regarding the proceedings here, very nice closing argument. Really good. I liked it, and yes.
Mr. Siemens, Attorney Siemens. Yes, what do you say about your colleague's closing argument?
Great. She really nailed everything down again. Above all, she also addressed the intent again, which is not present here at all. So, I can only say it was really very, very good. I liked it very, very much, and it brought everything to the point. And I find it important once again that, in the end, someone brings together everything that is on the table here, which speaks against embezzlement.
Were there any aspects that were new to you?
Well, the new aspect, which we briefly announced this morning, is this chat history between Dr. Justus Hoffmann and Dr. Reiner Fuellmich, in which Dr. Justus Hoffmann himself says that the money somehow needs to be moved from the GBR to the UG. That means he already knew there were no assets in the UG when he filed his criminal complaint. And that's the bombshell. We will see what we make of it.
Thank you for now.
Thank you.
Yes, so for me, Reiner Fuellmich should be acquitted. So it all has become clear again that there were two loan agreements. Practically, the assets are still there, or rather the donations. This pregug does not exist, as Katja Wörmer clearly elaborated in her plea, right? It is also very important that the adhesion plaintiffs, they have no claim to these donations.
That has happened before. A year ago, we were already, I believe, standing for Reiner at the Easter Port. I have one more, but yes, unfortunately not.
You can't say that at all. You still somehow educate what you do, what you are doing.
I really feel like crying myself, I must honestly say. Yes, I find that really quite terrible. This is really a catastrophe.
Ms. Wimmer, and if I may briefly interject, you have now delivered the closing BDW. How does the breakthrough feel after 50 days of trial, after 18 months of tireless defense?
Well, I can't really see it as a breakthrough yet. The word has now been taken from me, so to speak. There is certainly still a lot to say. I can always repeat it. And I also feel the need to keep repeating it because I feel like I'm speaking against a wall. And I want our argument to finally be heard and understood. You always feel like there's a wall. You can really feel it physically. Somehow you just can't get through. And that's the feeling I have here. Of course, I don't want to go shout or anything, but I'm trying to somehow break through, hoping there might be a point of connection, that something might click, leading to understanding or empathy or seeing things from our perspective. You once said they are always just at the level of harbor lawyers. They need to come to the level of the donors, the accused, anti-IGAT, and the Enlightenment movement here. And I believe this framing in their minds creates a barrier, as they always compare it to a commercially active LLC, which is completely off. That doesn't fit at all. The work was significantly carried out by the accused, also by Vivian Fischer, but it's, in a very significant way by the accused. And that was the reason for the donations. Without the investigative work of the accused, there would have been no donations. Maybe there would have been 100,000 euros and then the whole thing would have fizzled out after half a year, but not 3.6 million. And he also only thought about how to secure the money. That was very daring, it was very brave, and it was very unconventional. But he definitely intended from the beginning to secure the money and to return it or use it for the investigative work. He didn't seriously establish a Corona committee and think, oh, now we'll collect a lot of donations. I'll just pretend to be doing some investigation here. In reality, I actually find the Corona measures totally great, and I've been vaccinated 5 times. But I always tell people a tall tale. And once we have the 3 million, then I'll just slip away to Mexico. I don't know who really believes that. They believe in Santa Claus.
Let's move on to the start of the negotiations. As you mentioned earlier, you tried to break through this wall right from the beginning. In any case, you very energetically made space for yourself and conveyed to the chamber quite emphatically that you do not wish for any criminal charges or proceedings due to your statements as a defense attorney. What exactly did you mean by that?
That's apparently where we are here. I don't know if that will come true. I hope not. But obviously that's where we are, and we know that there are already criminal charges against us as defense attorneys, that the prosecutor involved in the case against Reiner Fuellmich is also pursuing us criminally. Among other things, because of these statements by Reiner Fuellmich, the public statements he made, still from prison, which were coordinated with the court and were also known to the correctional facility and the prosecution. The chairman informed them of this. It's all documented in the file and Turmos. And then, 3/4 of a year later, I am pursued by the prosecutor, who is also proceeding against Reiner Fuellmich, which I find very, very strange and unusual, that the same prosecutor is pursuing us. And there are supposed to be proceedings against other defense attorneys where they might proceed legally regarding statements or against legal representatives, trial observers here, possibly criminally. One does not know how far this will go. It is possible that the cases will be dismissed. But among others, the representatives of the prosecution who are sitting here with us in the room are supposed to pursue these matters. And I also find that very unusual. I have never experienced anything like this before. And additionally, it was at least rumored in this hater chat that they wanted to launch a barrage of complaints against us and that they want to file or have already filed criminal charges against me because I read out a statement from my colleague Misere, or a motion and an attachment, a protocol from a witness who observed something on the internet where no one is named, at least not the joint plaintiff, which was suddenly mentioned in this hater chat, as was reported to me. I don't look into it myself, but it was reported to me that they now want to file criminal charges against me because of it. So essentially for things that I express here in the protected area as a defense attorney in a courtroom during my plea. And I can express quite a lot as long as I don't insult the parties involved in the process or talk about them in vulgar language. That would, of course, exceed the bounds of a moderate court proceeding, but otherwise, I can initially assume all sorts of things about the facts and also express them in defense of my client. In this respect, as I have shown, this legal notice or procedural directive is completely unusual for a criminal proceeding or any court proceeding, because I cannot assume that the defense is accusing the court or the chamber of qualified false imprisonment just because we believe our client is innocent and should be released immediately in the detention review applications. The law provides that I can file a detention review application, and of course, not in all cases. Of course, as a defense attorney, I can also have clients who are indeed guilty of the crime, but where I somehow try to secure a lenient sentence for them. I might know that they committed the murder, but perhaps I can eliminate the base motives or reduce the sentence to 3 years or whatever it may be. But in this case, if I, as the defense, assume and can also argue that the client is innocent, then I can always file a motion for a detention review and say that it is unlawful to keep them in custody. And if I represent it this way, or also argue that this whole action with the kidnapping, yes, kidnapping in quotation marks in my opinion, but we consider it a kidnapping. We have also justified it that way. We even found a Stasi document on this where they referred to such, yes, the transfer of people under false pretenses as kidnapping in their Stasi terminology handbook. Interestingly, even though they did it themselves, you can now read all of this on the internet because this regime is currently under criticism. But if something similar happens here, which can be compared in this regard, because he was led to believe that the signature on the passport was missing, if he is lured somewhere with tricks and then flown out of Mexico without going through the formal extradition process, we can also call it that and name it as such. And this has simply not been recognized by the court so far. Perhaps I should have emphasized once more that this should have a mitigating effect on the sentence. Everything here should have a mitigating effect. But I deliberately didn't do that because we are demanding an acquittal. And if I now bring up what is relevant for sentencing or has a mitigating effect, then I would again be assuming that he does deserve a punishment. So that's exactly why I deliberately refrained from mentioning it again in this context.
You also read out a screenshot regarding the accusation of breach of trust. It is supposed to show that the adhesion claim was allegedly abusive. Can you repeat that again now? Where did that suddenly come from? So that was also news, the content?
Yes, exactly. This screenshot comes from the defendant's devices, which I have in secure custody since they were released by the prosecution after evaluation. Most of it is deleted there, at least the things that would be somehow relevant to us within the criminal proceedings. But we have now, as I said, found a post on a social media channel. I don't remember where it was. Also from the complainants, where, yes, according to this post, the complainant Justus Hoffmann apparently also assumed that it was a partnership until the UG was actually founded and registered. And the complaint was filed against the backdrop of claiming that the 4GOG and them as shareholders of a UG suffered damage. And the 4GOG was also an adhesion plaintiff here. So if one now says that even the complainants assumed it was just a GBR, then the 4GOG couldn't have been an adhesion plaintiff here. I mean, this has now become irrelevant anyway, the adhesion procedure, because the defendant, as mentioned, is insolvent. But that's purely formal. This reason, they are still pursuing the lawsuit. They have now registered their claims for entry into the insolvency table because they say it is a claim from an unlawful act. That does not expire and is also not affected by the priority or even by the personal bankruptcy. So they are trying to enforce it further.
Was the defendant's smartphone actually admitted as evidence?
The prosecution itself has evaluated these chat logs and these 2 emails, which the court and the prosecution mainly refer to. To substantiate the criminal charge, they were subsequently taken from the defendant's devices during an evaluation. No further admission is required for that. They are, when devices are present in such cases, it only came to their attention later after the defendant had already been in custody for a month because he had actually applied at the correctional facility for the devices to be handed over to his 2 defense attorneys. And in the context of this application, the prosecution then noticed, oops, it seems there are still devices, so let's evaluate them. And that's when they found these chats, which they then started to refer to from that point on. Sometime from the beginning of the year, I believe this note from the prosecution is dated the 9th of October 24, which they then refer to in content and say, this is now a covert trust. This is no longer a loan agreement because we have those emails, which I have also more or less quoted earlier.
Okay, then I'll let you have a lunch break first, and then we'll continue the interview. Thank you very much.
Thank you.
Sir, and the break is now over. What's next on the agenda? Will the client have the final word now?
Yes, my client will certainly speak the final word today, but not just today. He will need a bit longer for that. But we still have a very personal message from Dr. Justus Hoffmann to the court. I will add that today as the icing on the cake, so to speak. And then I'm curious to see if I will have the opportunity to plead again.
So it is relevant to corporate law what you want to present now. Do you think the chamber will engage with it?
It is procedurally relevant, and indeed to the highest degree. And the chamber will engage with it because I will ask the chairman to grant me another 5 minutes, and I'm quite sure he will give them to me.
Okay, good. Then good luck.
Thank you very much.
Yes, that was a very, yes, how should I put it? A very intense day today. I am deeply impressed by the strength with which Reiner Füll still presents himself here and does not let the chairman more unsettle him, nor does he let himself be restricted in any way. He repeatedly says that he only wants to restrict him, but he does not put up with it. So he is still unbroken. I admire that immensely after 1.5 years of unjust imprisonment under harsh conditions. One can hardly imagine that, and it is so obvious. Even after today's day in court, after everything that was said today, both by Katja Wörmer, Edgar Simon, and then by Reiner Fuellmich himself, that there can be nothing other than an acquittal. So from the beginning, there should not have been a trial at all. That is so crystal clear. And it is also so crystal clear that the judge is firmly convinced to pronounce nothing other than a conviction here. But you can see that he is not very comfortable with it. So you can still see a bit of human emotion. At times today, he also seemed uncertain when he suddenly couldn't remember the date and withdrew with his colleagues to the back room for a minute over trivial matters, only to later state an incorrect date. So he was noticeably more uncertain than he sometimes is. I think he's really feeling the heat.
Simon added a supplement to his plea. It's just so crystal clear, and it's simply unbelievable that they don't say, "We're sorry, Mr. Fuellmich, you must leave immediately." Today, Reiner pointed out to me once again that the whole thing has essentially become a criminal case with intent and not a normal civil case. And that indeed provides a tremendous procedural advantage for those behind all these proceedings. There is no official record keeping in this criminal case. I believe generally there isn't any in Germany. In civil cases, there is. And this allows for a lot of manipulation or steering to direct a case in a particular direction as desired. How do you assess the interruption by the chairman? Do you consider it appropriate or not? Well, since the file is labeled Corona greeting right at the beginning, it's clear that this is also a political case. And whenever the case touches on facts or other matters related to Corona, Reiner must, of course, address it for me. And at that point, the judge interrupts his plea and throws him off track. Thank you very much. Ms. Attorney Wormer, let's return to your plea. You outlined the historical course of the proceedings and repeatedly pointed out strange coincidences or unusual flows of information. What exactly did you mean by that? What was so strange about it? Yes, well, my colleagues and I are quite in agreement that there are many unusual aspects in this criminal proceeding, both in the past and present. I also mentioned at the beginning of my plea that I would have liked to present a proper plea, and I would have preferred a proper criminal proceeding. It started in effect with the fact that the client never received a proper hearing, not just shortly before the arrest warrant was issued, but also not immediately after the criminal complaint was filed. There were no investigations, no witness interrogations, and only after repeated vehement insistence was the witness Weisenborn finally questioned, but only shortly before the arrest, by Reiner Fuellmich and the former accountant shortly after the arrest. However, there was a year and a half before that when they could have granted him a proper hearing. And that has nothing to do with the arrest warrant, because I don't file a criminal complaint or start investigations and immediately think, oh, I have to arrest him now. He was still in Germany in September 22 when the criminal complaint was filed. So that's neither a reason nor an excuse. The court presented it that way. Then at the first detention review hearing, the judge at the district court said, during the granting of the right to be heard, to the client, I'm not interested in what you have to say. You consider judges to be puppets anyway. And it continued like that. We then also had the detention review hearing before the chamber, which was ultimately supposed to take place in writing. Only after my vehement insistence was there a date set for an oral hearing. Even then, one did not necessarily have the feeling that our arguments were truly followed, or that there was any interest in them, I must unfortunately say. And yes, then there were repeatedly hot oddities during the main hearing. For example, at the beginning of May last year, there was a legal notice from the court. Shortly before, there was a 1-hour podcast about the trial on the internet, which at least did not originate from us, where it was pointed out that the court would probably issue a legal notice soon It could have been a coincidence that it was actually issued shortly thereafter, but...
Yes. Possibly information leaked from the prison. We cannot prove that. But there were some oddities that I pointed out, which I don't necessarily want to repeat in public now.
You also mentioned an email exchange with the prosecution that could indicate close-up coordination. Can you say something about that?
Well, basically we know that the two of the complainants who were also the adhesion plaintiffs in the case, former adhesion procedure, Antonia Fischer and Justus Hoffmann, that there was very close coordination via email with the investigating prosecutor. But Vivian Fischer also eventually started sending a lot of information to the prosecution here. And then there was one day, I looked this up yesterday, where I believe she sent a total of even 5 emails to the prosecutor. And yes, it was not in... Well, first of all, I find it unusual to write emails to the prosecution and the court. I don't usually do that. Normally, as a lawyer, you are much more formal and use the special electronic lawyer's mailbox or the mail or fax. Email is very personal. And generally, you don't even have the personal email addresses of the investigating prosecutors or judges, unless you are personally involved in the proceedings. And I always write, Dear Mr. or Dear Ms. And, here the address was Dear Mr. John. And I find that quite special, let's put it that way.
Addressing a prosecutor as Dear Mr. John is a level of familiarity that I actually no longer consider acceptable, even as a complainant. So I say quite honestly, that raises questions about how such a familiar form of address comes about. I need to know someone a bit longer and more intensively to change from Dear Mr. Prosecutor to Dear Mr. John. I find that quite noticeable.
She was not the complainant, not that we get reprimanded again.
I have to take that back. She is not the complainant, but as I said, the mere fact that she communicates with him as Dear Mr. John is extremely strange. Mr. Rechtsanwalt Siegmund, you were allowed to make an additional plea in light of a new aspect that Ms. Vermer also brought up in her plea today. Why was that so important to you again?
Well, what can I say? Katja Vermer thankfully found something that we absolutely needed, which essentially completely supports all my previous statements. She unearthed a chat, I have to say, because there is, of course, a lot of data that needs to be evaluated. And there is a chat history between Dr. Reiner Fuellmich and Justus Hoffmann before August 28th, 2021. So right in the middle of the events. It contains the following. Dr. Reiner Fuellmich writes, yes, that's how it should be, but I hope that the foundation itself will finally be recognized as well. So it was about the foundation not being recognized as charitable. And that's what he wrote. And then Justus Hoffmann writes in response, the problem is more about how we get the money from the current committee partnership into the UG. Get the money from the current committee partnership into the UG. That means the UG had no assets.
That also means there won't be any corresponding damage.
We need to read further, without us having problems with the charitable status later. So he also knows that the charitable status is not there, right? So neither with his partnership, which he believes is the one that has the money, we know that it is not the case. It is only the partnership between Reiner Fuellmich and Vivian Fischer, not the partnership of the 4 people. And he writes that he could have problems with the charitable status. And then he continues writing, and here the wording is quite significant. He writes, with the recent jurisdiction of the Federal Fiscal Court, from my perspective, the only way is, and here it comes, to bring in the current money through a capital increase. With a shell purchase, we are more likely to encounter problems. So apart from the technical things mentioned here, he talks about money. That is an absolutely derogatory term. Yes, but it is a derogatory term towards those who perhaps tried to support my enlightenment with their last euro. This means it also supports what we already know from other chats of his, namely with Vivian Fischer, that what the Aishum resistance thinks is completely irrelevant to him, and he has much bigger fish to fry. You can clearly see here that the man is absolutely disrespectful towards those who provide the money to support the Enlightenment here. And we also know that Enlightenment was not the goal of the society.
Well, one could, of course, counter. The Enlightenment was indeed the goal of the Corona Committee.
Yes, but that's not the society. The society was supposed to become the GUG, and we have the wonderful decision from the Higher Regional Court of Braunschweig, which states that the purpose of the society is to promote specifically art, science, and culture. And that was it.
But wasn't enlightenment the intended goal of the UG? I mean, one could also say that you need the money for the purpose of the society.
Yes, but the purpose of the society is, as we now know, not enlightenment. The purpose of the UG, mind you, the purpose of the original GBR between Vivian Fischer and Reiner Fuellmich has always had only one purpose, namely enlightenment. And they carried that out from start to finish. Then there was the four-person GBR, where Antonia Fischer and Dr. Justus Hoffmann joined. And their goal was the founding of a GmbH, meaning UG, a small form of GmbH, and from that to later develop a foundation. So that means the purpose of this company, the UG, was never to raise awareness, but the narrowly defined area was first establish a UG. And they didn't succeed in that because the registration did not take place. And that's why there is no capital in the UG. It's quite simple, and Justus Hoffmann recognized this very early on.
And an important point is also, which I have emphasized again, after you already mentioned it, that the viewers knew nothing about the corporate law implications in the background, because only a donation account was always displayed. It was always a lawyer's escrow account because the UG, due to lack of registration, never had its own account, this FOGOG. So they only ever saw a donation account. They only ever read Corona Committee. The articles of association were not published on the site, and nothing was published about there being a FOGOG or any company at all. So they simply donated for the Corona Committee, for the educational work of the CC, and that's exactly what is stated in the subject line of the donation receipts.
Correct. And one thing might be quite important. I believe one of the accounts wasn't even a lawyer's escrow account, right? Wasn't that the case?
That could be. Well, but from Reiner Fuellmich and Tobias Weissenborn, those were definitely lawyer accounts and also escrow accounts. It could be that later on, perhaps due to the constant account closures, also with Reiner Fuellmich, there was simply just a business account. That would be due to the urgency of the situation.
Yes, because if you no longer have an account, you have to find some other way to manage. Exactly right. There were 5 accounts that existed, one after the other.
What would be the conclusion from this screenshot? That no financial damage occurred on the side of the GOG? Or what are you trying to say with that?
Yes, that's exactly it. Because where there is no wealth, no financial damage can be done. Yes, that's quite logical. I mean, with that, the entire accusation. No, one must start differently. The report, the indictment, the trial, the opening of the trial, and the main hearing that has now been conducted, and above all, the arrest and imprisonment of our client, are completely unlawful. You know, it's just because the report was already based on a misrepresentation of the facts.
Yes, with another inaccuracy. The complainants also had this opening resolution at the time, and where there was an individual representation authority and an exemption from self-dealing. They had conveniently forgotten that when filing the complaint. And then we must say that this dismissal order by the senior public prosecutor, where the court wrote in its procedural order that it would be misleading for the defense to always refer to it. However, it is not misleading because senior public prosecutor Reinecke, I believe we have mentioned the name several times, correctly recognized that the corporate law implications were not at all clear to the audience and the donors. The donors donated, and if there could have been any fraud, it would have been at the expense of the donors, because they donated directly for the educational work and for the CA, for the 2 lawyers who were there and provided information, whether it was a company, and above all, who was part of the company. As I mentioned again yesterday, was completely unclear. It could also have been that Wolfgang Wolak or Martin Schwab was a partner. They both appeared frequently, regularly. Or maybe there were 20 other people in the background, some silent partners, or Mr. Siegers. Yes, exactly. So it was completely unclear, and that's why it can't be that people donate to something they don't know at all.
Right. They only see what they see, right? And those are the 2 partners, Vivian Fischer and Reiner Fuellmich. And Martin Schwab certainly does not belong to the circle of partners. No, but that was unclear.
Yes, One can always say afterward that there might be a company of 20 people behind it whom no one knows and who have some goals and intentions. At the very least, the articles of association should have been posted on the internet or displayed somehow so that donors could have some idea.
What can the public still expect from the next days of the trial? There are still 6 days left, I believe.
Yes, so these court days are always preemptively scheduled by the chairman, and Reiner Fuellmich is now at his closing statement. He will also want to elaborate on several points. We have scheduled 3 days next week and 2 days the following week. At some point, we will naturally come to an end, I think. We might possibly file additional motions for evidence. I am not exactly sure about that yet, but eventually there will, of course, be a verdict. We can't foresee exactly how long it will take.
Thank you very much for the interview. See you next time.
You're welcome. My pleasure.